right to information was an implicit fundamental right that, as discussed earlier, it was also made explicit under certain legislations, but with limited applicability. One such instance of a right to information that was implicit in a legislation was the Consumer Protection Act of 1986. Indeed, the Consumer Protection Act provided that every consumer has a right to be informed about the product or services that he is obtaining from a producer or a retailer or a service provider. In this regard, it is pertinent to note that his right to information pertained to all the hazards, including the contents of the product that he is being exposed to, and as such, the right to information is also a culmination of various other legislative rights. Similarly, the Factories Act of 1948 also provided for compulsory disclosure of information to factory workers regarding the dangers of health hazards and other measures that they can undertake to overcome such hazards. On similar lines, the Environment Impact Assessment regulations, which were given under the Environment Protection Act of 1986, also ensured that the potential risks that persons would face owing to the hazardous processes or the industrial process that an industry was exposing to its surroundings was also made evident, and as such, right to information had also found its place in several other ministerial legislations, but however with limited scope of application. The Representation of Peoples Act, as discussed earlier in the PUCL cases, had also made across an amendment in 2002 so as to allow for the disclosure of the status of the persons who were contesting for the elections. Now, with this, it is quite evident that the Right to Information Act had found its place in the legislative scenario as an outcome of various judicial decisions and various conventions that India was obligated to. As such, its exposure as a whole standing fundamental right against the government and its information was something that was evident. The Freedom of Information Act of 2002 was one of the first legislations that gave across with regard to the right to information in detail. But however, there were several controversies that marred this legislation. Few of them was that the Act exempted the disclosure of information that was exchanged in confidence between central and state governments and any other authority or its agencies. As such, the particular exclusion was found to be wide enough and would create across ambiguity in dissemination of information when the right has been exercised. Secondly, the various aspect was the legislation was much regarded as a toothless tiger, in the sense that although there was a right that was created in the citizen to procure information using the enactment, however, there was a difficulty or ambiguity that was placed in wherein there was no penalty that was provided against the officials who offended or were found to be in violation of the particular enactment by way of refusal to provide information. At this juncture, it is pertinent to understand various civil body movements that actually led across to the growth of the Right to Information Act of 2005. The Freedom of Information Act of 2002 was held as incapable of meeting the requirements of a transparent, free and fair governance system and structure that allows for free dissemination of information to the public. On the aspect of civil body movements, the role of the Mazdoor Kisan Shakti Sangathan from Rajasthan is something that is noteworthy to read and understand. The Mazdoor Kisan Shakti Sangathan was established in 1987 by 3 founding activists in a rural area called Devdangri, which is in the state of Rajasthan. It was formed by 3 major activists. One, Ms. Aruna Roy, who was earlier a member of the Allied Indian Administrative Service, who quit the particular pivotal role and then decided to work across on the grassroots for greater empowerment of the poor. Along her was Mr. Shankar Singh, a resident of a nearby village, and Mr. Nikhil Dey, who all were working towards the upliftment of the poor and the rural communities in and around Rajasthan. They formally registered their organization in 1990 along with membership from various marginal peasants and landless workers, and majorly from persons belonging to the lower socio-economic. Their activities took a wide span when in 1994 they decided to challenge the corruption that persisted in the Rajasthan government on the issue of underpayment of daily wage earners and farmers on government projects. Initially, there was an attempt made by the MKSS to obtain information from the Rajasthan government with regard to the muster rolls and the bills and vouchers related to the purchase and transportation of materials and the payment for these daily wage workers. And subsequently, there was an attempt that was made to cross-check the information that was obtained from the government through public hearings against actual testimonies that were given by the workers themselves. This method of public hearing gained immense popularity and was successful in drawing the attention of the corruption and exposed the leakages that were there in the system, and it marred the situation of corruption. The concept of Jan Sunwais, which was related to the public hearing that was conducted, gained greater attention and focus from the media, and is a means of creating transparency and accountability as well as empowering the poor. One of the major challenges and hurdle that was faced by the Mazdoor Kisan Shakti Sangathan was with regard to the collection of the information. It was observed that they had to go and undergo a great amount of deal and stress and tenure to obtain these information, and as such they required a need for a particular law that allowed for dissemination of government information. In April 1995, looking into the aspects of the MKSS, the Chief Minister of Rajasthan had announced that the government of Rajasthan would be the first of the state governments to provide for access to information to citizens on all local developmental works. But however, it was not until 2000 that the government was able to legislate such an enactment. The Dharna in 1996 held by the Mazdoor Kisan Shakti Sangathan was one of the pivotal reasons as to why the government went across to look into the aspect of enacting a legislation on the right to information. However, the Dharna kept losing its vigor with the government lapsing in its promises. These Dharnas involved the association with the National Campaign Committee for the People's Right to Information. The NCCPRI, along with the Press Council of India, was able to give across the first draft on the right to information in 1996. It's pertinent to look into the Press Council of India's draft, which was given in 1996, wherein it affirmed the right of every citizen to information from any public body. Further, it is pertinent to understand the definition that was given across in this draft, that the public body included not only a government or an authority of the state, but also all privately owned undertakings and non-statutory authorities, companies and certain other undertakings which were existing and functioning in India on account of public interest. The criteria for the information to be disclosed was kept broad and vague in the manner that any information that could be sought by the parliament or state legislatures cannot be denied to a citizen either. There were also penal provisions that were given across for the failure or breach of the duty by various authorities in the dissemination of the information. Subsequent to this, a conference of chief ministers was organized for looking into the drafting of a law on transparency and the right to information. Between 1997 to 2002, several other legislatures of the state had passed legislations on the right to information. In May 2004, with the new UPA government coming into power in the center, a national campaign on the right to information was given a major boost with the UPA government's Common Minimum Program, which promised that the Right to Information Act will be made progressive, participatory and meaningful, thereby requiring the repeal of the Freedom of Information Act of 2002. A National Advisory Council was set up under the chairmanship of Mrs. Sonia Gandhi for overseeing the implementation of the government's Common Minimum Program. The National Advisory Council was put in under pressure by activists such as Ms. Aruna Roy, who looked across or oversaw the activities of the National Campaign for People's Right to Information Act and consistently put across pressure on the UPA government to have the bill passed and enacted, the Right to Information Act of 2005 as we see it today. Amidst all these measures, it is pertinent to note that the Freedom of Information Act of 2002, which was passed by the Parliament, had never been given impact by way of a notification in the official gazette. Public interest petitions were filed by Advocate Prashant Bhushan on behalf of the NCPRI and the Center for Public Interest Litigation since 2002, who have the implementation of the Freedom of Information Act. Consequential to the order of the Supreme Court, as well as the pressure that was put in by the NCPRI and the recommendations that were taken forward by the National Advisory Committee, there was a decision that was taken to introduce a new bill on the right to information based on the recommendations thereof. On 10th May 2005, the RTI Amendment Bill of 2005 was tabled before the Lok Sabha and was passed subsequently by the Rajya Sabha and was given full effect by President APJ Abdul Kalam on June 15, 2005. With this, we come to the end of the session on legislating of the Right to Information Act, its backgrounds and challenges.